Hello friends, welcome back to Easy GST for you. Today we are going to discuss another interesting judgment delivered by Honorable Kerala High Court in case of Malabar Fuel Corporation. Now the matter is pertaining to the refunds under inverted duty structure, meaning the tax on inputs is higher than tax on outputs, creating a situation where there is an accumulation of input tax credit which can be claimed by the taxpayer as a refund as per section 54 subsection 3 of the GST Act. Now this particular judgment is special because similar kind of a judgment was already delivered by 3 or 4 high courts in the past. Usually what happens in case, especially in case of refunds, there have been two mega circulars, 125 and 135. So authorities prefer to stick directly to the circulars and the wordings and instructions given in the circular. Though many a times these few aspects of the circular have been challenged at various high courts, and court has granted a relief to the taxpayer, respective taxpayer, stating that the conditions or the mentioning in the circular is probably ultra vires to the provisions of the law or not appropriate. But still, we usually observe that if that particular judgment is not related to the state in which the taxpayer is operational, then authorities are not granting relief based on the ratios of the judgments provided by other state high courts. So similar was the case. This is from the state of Kerala, wherein the taxpayer Malabar Fuel Corporation was involved into the activity of filling the cylinders of LPG, liquefied petroleum gas, for which they used to take bulk LPG at the rate of 18%, and they used to sell it to the domestic as well as commercial. Now here the rate for domestic recipient was 5% and for commercial it was 18%. So that created a situation where there was an accumulation of ITC. Now there was circular 135 wherein the para 3.2 specifically mentioned that if the input and output are the same commodity and there is a accumulation of ITC, then in such a situation the refund should not be this situation is not getting covered under the inverted duty structure of section 54 subsection 3 of the CGST Act, and hence the refund cannot be claimed. Now this particular para 3.2 of the circular has been challenged previously at Rajasthan High Court and various Guwahati High Court, Delhi High Court, and all the courts had given the judgment in the favor of the taxpayer. So similarly, here also Kerala High Court has delivered the judgment granting the relief to the taxpayer, stating that the taxpayer is very much eligible to claim a refund even though the input and output are the same commodity, and creating a situation of inverted duty structure due to little bit difference in the rates. The taxpayer is very much eligible to claim the refund. So this is a very important judgment, and I think this will help many of the taxpayers in getting reliefs. So thank you so much. Have a nice day.